Okay, so now that we've talked about the market and the political landscape, I'd like to just spend my last few minutes talking about capturing opportunity and managing your risk while you do that. So as Dr. Jin said, and as Fan said, there have been a rise in energy-related bankruptcies. Dr. Jin spoke a bit about Chesapeake Energy. Chesapeake Energy settled a $6 million class action lawsuit today with many of its landowners because it had been slow paying royalties. The landowners are becoming increasingly sophisticated and organized in trying to protect their interests against producers. And Chesapeake is a good example of the impact that organized landowners can have on the prospects of an energy company. So Chesapeake posted a first quarter loss of about $8 billion and has indicated that Chapter 11 is not off the table. So when there are energy companies that are entering formal bankruptcy proceedings, that creates the possibility of purchasing assets both in those formal proceedings and then also prior to the formal proceedings when the companies are distressed. So what do we think about when we think about buying assets out of a formal proceeding? Can we go to the next slide? Okay, so a typical sale in bankruptcy where the debtor is in possession of the company is done under Section 363 of Chapter 11. And the process is pretty straightforward, although the exact procedures will change slightly depending on which bankruptcy court we're in. But it goes something like these 10 steps, and I had to add the 10th step to celebrate to round it out. So the debtor in possession will market the assets, and they will do that in a variety of ways, mostly to like existing prospects or also to their creditors, and I'll get to that as well. So the debtors will market the assets, people will sign non-disclosure agreements, data rooms will be set up for due diligence, and then there will be a series of bids, and then ultimately the highest bidder after that initial round of bidding, called the stalking horse, will be selected. So this is when at that initial stage of marketing, the stalking horse will emerge, and the debtor will negotiate a purchase agreement with the stalking horse in order to set the price floor. Then the purchase agreement between the stalking horse and the debtor in possession will be filed with the bankruptcy court, and there'll be a hearing to approve the bankruptcy plan. Then after that, there is an additional marketing period and then an auction. Now, interestingly, these auctions are live. Like they're often in law firm conference rooms, and the stalking horse is the floor. But if there is a bidder that's higher than the stalking horse, then that bidder will be able to take over that purchase agreement that has already been negotiated and approved by the bankruptcy court. Now, if you were to bid on assets in this situation and you were the stalking horse, you would benefit from some sweeteners that are put into the mix for that potential bidder, for the stalking horse. They often have breakup fees, reimbursement for some of their expenses, or bidding terms that are favorable. And so once you have your buyer, either the stalking horse or a higher bidder, then you have a hearing to approve the transaction, and it closes and everyone's happy. So what are the advantages and disadvantages of participating in sales within the bankruptcy process? The advantage is that the procedure is very clear. And I guess probably the most important advantage for the purchaser is that you're getting those assets probably at a pretty good price, free and clear of all liens and claims. You'll have the opportunity to renegotiate onerous contracts when you acquire the assets, you may be able to renegotiate onerous contracts with those counterparties. The bankruptcy court approves the sale, so you're never at risk of a potential clawback due to a fraudulent transaction. And there's also a particular incentive for creditors through credit bids. So if a creditor is owed money, then instead of paying cash for the asset, they can just bid to the amount of money that they're owed. The debt will be written off and they will acquire the asset. It's sometimes very attractive for major creditors, especially industry creditors. And finally, if you are the distressed company and you're selling a distressed asset within this procedure, then you can be sure that you've satisfied your fiduciary responsibilities because the bankruptcy court has to approve the transaction. Challenges, which speaks to a little bit of what Dr. Jin was saying, is that these are time consuming and you need creditor support. The bidding is public, so people will know what you are willing to pay for that asset. There are 2 stages of auction. And then finally, if you're interested in acquiring the assets and assets of a US-based entity, and you are a foreign entity, then you have to also grapple with regulatory considerations under CFIUS. I'll talk a little bit about that at the end. So if you're doing acquisitions outside of the bankruptcy process, then you get some advantages. Speed, confidentiality, there's no complicated bid or auction process, but you have to be very careful when you do your due diligence for a number of reasons. Due diligence is always very important. You need to know the value of what you're acquiring and the risks that you are acquiring when you get that asset. And when you're dealing with distressed assets, very often there may be difficulty. First of all, there may be debt, there may be onerous contracts. You may have issues with personnel. There could be extra litigation risk. And so particularly in a distressed environment, you have to be very careful to do your legal due diligence to ensure that you understand what you're acquiring. I think that some of our other speakers will talk a little bit about the importance of environmental due diligence, which is probably one of the most important considerations in assessing any energy asset. But the thing that I just want to highlight is that anytime that you're buying an asset from a company that is almost about to go bankrupt, then that transaction is vulnerable to clawback as a fraudulent transaction. So in that situation, first, either you want to make sure and satisfy yourself that the company is unlikely to go bankrupt within a 2-year period after the acquisition, or you need to make sure that you're paying a fair market price for the purchase of the asset, that it's not a sweetheart deal. And so, but if you can satisfy yourself as to the value of the asset and protect it from clawback, then buying a distressed asset outside of a bankruptcy process can be a great way to get a good deal.
Maureen, you only have 2 minutes left. 只有剩2分钟.
I can do it. So 2 minutes on CFIUS is a challenge, but we'll
okay. You can get a little bit of extension, little bit of extension. No more than 5 minutes.
Oh, okay. Thank you. So the Committee on Foreign Investment in the United States, which was then recently updated by FIRMA in 2018, has mandatory filing requirements for certain transactions where there's a state-owned or state-controlled acquisition of critical infrastructure. That includes energy infrastructure, as I'm sure you all know. But in addition, there are brand new rules that grant the authority to review non-controlling interests, which are typically less than 10%, in critical infrastructure where the foreign entity has acquired certain rights. That authority to review those interests also applies to foreign limited partners that are participating in private equity. So it's critical to structure the deal to avoid the CFIUS review. And that's not because it wouldn't ultimately pass a CFIUS review, but because the CFIUS review takes a long time, but also they're just about to pilot fees. So eventually you're going to have to start paying fees to the US government to approve the transaction. And the way to structure the transaction in order to avoid this authority to review a non-controlling interest is to ensure that you're not giving the foreign entity, or the foreign entity isn't acquiring these rights, a board seat, an observer role, access to material non-public information, and executive involvement in decision-making. So if the entity is simply a passive investor, then even if it's more than, or even if it's a non-controlling interest that would otherwise hit the threshold, that it may not be vulnerable to a CFIUS review, which will enable the transaction to close more quickly. Next slide. So to close, I think that I want to just go back to our touch point of the key principles of being proactive, agile, and then disciplined. That always applies to our to how we think about how we serve our clients and helping them to understand their legal risks and to navigate those, but particularly in a volatile situation or in a complicated market, it becomes particularly important to develop those good habits. I'd be delighted to talk to you about your own businesses, excuse me, about your own businesses, critical contracts and key vulnerabilities, and see if it's not possible to emerge from this particular situation more competitively. Thank you so much.